Have you ever been in a situation where you know something important, something that could make all the difference, but you're not allowed to talk about it? Well, today we're diving into a story just like that. It's a story about a long, careful legal journey, about trying to navigate unclear rules, and at the center of it all, one very important, very silent document. 513. That's the number of days the people at the heart of this story have been in a legal battle. That's a long time. It's a calm, factual statement that this has been a marathon, not a sprint, and they're still going.
And what's at the core of their claim? This number, 139. That's how many straight days of round-the-clock support they provided, all without a single penny of funding or assistance. These aren't just numbers on a page. They're the foundation of a very long, very careful struggle. So, early on, something important happens. The court orders that an audio recording from a settlement conference be transcribed, basically typed out. And just like that, a new clock starts ticking. For 41 days, the claimants wait, checking the system until finally, a new file pops up.
Now, they weren't expecting a huge verdict or anything. They just figured they'd get a simple transcript of what was said. But when they opened the file, the title was, well, it was a bit of a surprise. It was very formal, very official sounding, Oral Reasons for Judgment.
Inside, it was just 3 pages, with those wide margins and big spacing you see in official court papers. So the big question is, what did it say? And the honest answer is, we can't tell you. They can't tell you. And that strange restriction is really what this whole explainer is about.
And this part is absolutely crucial. The power of this document isn't about some bombshell quote hidden inside. Its real significance is the simple fact that it exists. It's an official record. And that fact alone, they believe, provides real, factual support for their position. It's not just another piece of paper.
But here's where it gets tricky. The meeting this document came from was a settlement conference. Normally, those are off the record. They're confidential. You can't talk about them. But the document itself looked and felt like an official court paper, which is on the record, something you absolutely can talk about and quote. See the problem?
So you have this collision of two ideas. Is this a private negotiation that has to be kept secret? Or is it a public court document that can be used to make their case? The claimants were suddenly walking a very fine legal line. And this all boils down to one critical question. What is the legal status of this document? Now, for anyone representing themselves, getting this wrong isn't just a mistake. It could mean being accused of breaking confidentiality, and that's a serious thing. You can't just guess. A wrong move, a careless quote, and you could be in real trouble. They couldn't just hope for the best or assume it would be okay. They had to know for sure. So what did they do? Well, they took a really mature, really responsible position. They decided, we are not going to guess. Instead of taking a risk, they chose to go back to the court and ask a simple question. What are the rules here? What are we allowed to do?
They actually filed a formal application with 4 very specific questions. They basically said, first, is this thing confidential at all? Second, if it is, can you tell us exactly which parts we can't talk about? Third, if it's not confidential, what are the boundaries for how we can use it? And finally, if the whole thing is off limits, then please give us a formal order that says so, plain and simple, no more ambiguity.
And while they wait for that official answer, they made a rule for themselves. They decided to treat the document as conditionally confidential. Basically, they're acting as if it's completely secret until the court tells them otherwise. So, just to be completely transparent with you, that self-imposed rule is why we're being so careful today. We can tell you the document exists, we can tell you they're waiting for an answer, but what we can't do and won't do is quote it, summarize it, or use its contents in any way. They've chosen to err on the side of caution, and we're respecting that. As of right now, no response to their application has come through. The file is still, in a very real sense, pending clarification. They have what they need, but they're stuck in this state of waiting for the green light from the court. So that's where things stand. They have a piece of their own case in their hands, but they are responsibly holding back until a judge tells them exactly what is and is not allowed. It really is a story about the tension between knowing something and having the discipline not to use it improperly. And so, on day 513, the story just pauses. The claimants are holding this potentially pivotal document, but they're bound by their own principled decision to wait for clarity.
The next chapter will only begin when the court responds, and only then will we all find out if this document can finally be brought into the light or if it's destined to remain a silent part of this long, careful journey.